Hello, and welcome to the third and final in a three-part virtual CLE course series. Pace Nation, in collaboration with Winston & Strawn, are happy to have you joining us today. At the end of the presentation, we're going to give the audience an opportunity to ask questions. So you can click the raise your hand button, and I'll announce your name and unmute you. Note that sometimes we've experienced the attendees have your phone muted on your end, so are unable to hear you. So just make sure when it's your turn to speak and I announce you, you unmute yourself. Also note that after the course, we will email this deck and the video recording to everyone who registered, along with a form that you must fill out to receive your CLE certification. Now I'm going to turn it over to our CLE course series partner and moderator, Pete Morgan, from Winston & Strawn to introduce the speakers and begin the course. Pete?
Thank you, Sarah. Thank you all for joining us today. We are yet again presenting an excellent group of CLE panelists for this panel, covering a very important and emerging topic that affects those who are in the middle of doing PACE transactions and those of us who try and affect the capital market sides of those deals. I'd like to start by going through names of each panelist and having them each quickly introduce themselves. First, we'll start with Rick Doherty, who is with the U.S. Department of Housing and Urban Development.
Well, thank you. Hi, everyone. I'm Richard Doherty, or Rick. I'm currently a branch chief in the Asset Management Division based in Hartford, Connecticut. The longer bio is up on the screen, but I've been with HUD about 21 years, 19 of which have been in various leadership positions. I am a lead AP and for many years worked on a variety of green retrofit type programs for HUD. So also Bob Iber, who you'll hear from in a moment, tapped me a few years back to help assist with the implementation of HUD's PACE memorandum, which we'll be talking about in a little more detail today. Thank you.
Thank you, Rick. Next, we'll hear from Carrie Hallberg, a partner with O'Malley and Hirschler.
Hi, my name is
Carrie Hallberg O'Malley with Hirschler. Sorry about that.
Thank you. I thought I got an upgrade to the letterhead. I'll take it. Hi, my name is Carrie O'Malley, and I'm a shareholder at Hirschler. I co-chair the commercial real estate finance and investment practice group at the firm, and I'm based in our Fredericksburg, Virginia office. I have over 24 years of experience in the commercial real estate and finance area, and I've been working on PACE since probably about 2016. I have experience working with pretty much all of the PACE stakeholders, from property owners and capital providers to municipalities and program administrators. And of the 22 states plus the District of Columbia where there are active PACE programs and they've actually closed transactions, I have PACE experience in about 13 states plus the District of Columbia. And I'm thrilled to be on this panel today, so thank you.
Thanks, Carrie. Next, we'll go to Bob Iber, who's also with the U.S. Department of Housing and Urban Development.
Thanks, and good afternoon, everyone. Good morning to those on the West Coast. Bob Iber, Senior Advisor in Multifamily Housing out of HUD headquarters, 33-year HUD employee, and I have been involved with PACE implementation in HUD multifamily since its inception, which we'll talk about today is the HUD guidance notice that we issued in January of 2017. Look forward to talking to everyone and hearing from folks, and we're hopeful that through this we can demystify part of the HUD PACE review and lender consent process, and look forward to sharing information. Thanks.
Thanks, Bob. Next, we'll move on to David Schaefer with Counterpoint.
Thank you, Pete, and good afternoon and good morning to everybody. I'm the Chief Operating Officer of Counterpoint Sustainable Real Estate and its affiliates. Counterpoint was organized in 2013, and I joined Counterpoint in 2015, having represented them from inception. Counterpoint is a program administrator in 3 states, California, Florida, and Illinois, and provides capital in almost 24 other states. Prior to joining Counterpoint, I was the deputy chairman of Loeb & Loeb, an international law firm.
Thank you, David. And finally, Andrew Zeck with Greenworks Lending.
Yes, hello. Nice to talk to everybody today. My name is Andrew Zeck, and I'm a principal with Greenworks Lending, a national C-PACE lender with offices in 6 different states and a lending presence in every active PACE market. As a firm, we originate and lend on C-PACE transactions and administer and service PACE transactions. And I've been with Greenworks since we started the firm almost 6 years ago. And in that time, I've closed over 300 different PACE transactions and gained consent from over 90 different mortgage lenders. I'm so excited to share that experience today.
Excellent. Thank you, Andrew. So moving on to our next slide and getting into, this is primarily what we're going to focus on for this course today. Ultimately, our goal is to understand why are consents or acknowledgements needed for commercial PACE, where do we get them, when do SNDAs become relevant, why would a senior lender even agree to these sorts of consents, and you know, how do they affect the capital markets? And then importantly, as HUD has become more of an as people have realized that they need to get involved with HUD programs, what is HUD requiring as part of the lender consent process? So those are our goals for this course. And let's move to the next slide. We're gonna kick it off with David Schaefer first walking us through what is the difference between a consent and an acknowledgement and notice and how they all fit into this greater C-PACE scheme. So David.
Thanks, Pete. So yes, I will be trying to set the table for most of the other topics that will be addressed today. I'll be describing these elements in fairly broad contours of what you can expect to find when you're in this mix. Also, I will just note here that PACE is a state-enabled program, and from state to state and program to program, there's a lot of differences in both what is required and in the terminology. And sometimes different terms will be used to mean the same thing. So the universe of senior lender involvement in the origination of the PACE process involves basically 4 different levels. There's lender consent, there's the lender acknowledgement, there's the notice to lender, and in some states and programs, there's no obligation to obtain lender consent, acknowledgement, or even provide a notice to a lender. And we'll touch on these in a little bit throughout this presentation. Next slide, please. So the source of lender consent, and most of what I will be discussing here, are the state statutes and the local ordinances that actually implement PACE programs that are enabled by the states. Other sources of where lender consent or acknowledgement or notices could be required are in the actual program requirements, meaning the program administrator of a particular program has a requirement that was not necessarily authorized by the statute or the ordinance that set up the program. Capital markets participants, the rating agencies, and the lending documents to which a property owner is subject, and it will not necessarily be just their mortgage loan documents. Next slide, please. So what is the ask among these different categories? In the typical lender consent scenario, the property owner is requesting that the lender actually consent to the levying of the assessment lien and the terms and conditions of the assessment. The lender is also making either a representation or a certification or otherwise acknowledging that it will not exercise its rights to cause a default or to accelerate its loan by virtue of the assessment being levied on the property. And the third ask is that the lender acknowledges that other participants will be relying on its consent. Obviously, it's the property owner who's seeking it, but it will also be the program administrator and other third parties that would be relying on it, particularly in the capital markets process. An acknowledgement basically is what it says, is that the lender is only asked to acknowledge that it has received some notice or disclosure from the property owner, and it is not making the representations, certifications, or granting the consents that are described above. And finally, a notice, obviously, it is just simply putting the lender on notice that it intends to agree to an assessment and the assessment lien being levied on the property. Next slide, please. So here's where we see that there are really, not a lot of differences fundamentally between the consent and the acknowledgement. All three involve providing essentially some notice to the lender and disclosing the terms of the assessment and the assessment lien. What I call the next category, subject to lender underwriting, that's not so much a requirement, but that is the nature of the lender seeking to determine whether or not it will provide its consent or its acknowledgement. In practice, even though acknowledgements will typically only ask the senior lender to acknowledge that it received the disclosure of the terms, most lenders take the position that if they are acknowledging rather than just consenting to those terms, that it would be deemed to be an effective consent, and therefore most lenders in our experience will go through the same underwriting process in whether or not to grant the consent with determining whether or not to provide the acknowledgement. And of course, in both the consent and the acknowledgement, the lender is required to respond, and it's a condition usually either to the placement of the assessment and the levying of the lien that affirmative response is actually provided. The last category, what we mean by subject to negotiation, is that not infrequently in practice, lenders will seek to make their own asks as a condition to providing either the consent or the acknowledgement, basically an attempt to modify or supplement what is being asked. And these cover a fairly broad spectrum of asks, from actually asking the property owner to subordinate the PACE lien to the lender's security interest, or to have notices of a failure to pay, or rights to cure, forbearances, basically the types of things that you might expect to see in an intercreditor agreement is oftentimes what you will see from lenders. In most cases, it is sort of beaten back, at least in our experience, because some of the forms and the requirements of the lender consent or acknowledgement are prescribed by statute, ordinance, or program, and there is really little ability to modify those. Also, some of the asks of senior lenders would in effect require the tax collecting and billing and enforcement authorities to modify their processes, which they will generally not do. So in some cases, there might be side arrangements established, but generally there is a process by which lenders will often look to modify the ask. Next slide, please. This slide just simply outlines what you will generally find in most consents, acknowledgements, or just the notices. Typically that the PACE lien is senior to the mortgages or any other private indebtedness. Usually a very brief description of the improvements being financed, simply energy efficiency or renewable energy or things of that nature. The aggregate amount of the assessment or what's being financed, the annual payment amount and the term, and again, a statement that there will be a third party relying on the consent or the acknowledgement. And back to you, Pete.
Thank you, David. So now that we've sort of table set the differences between an acknowledgement, a consent, and a notice, we're going to turn to Carrie O'Malley, and she'll tell us where are these consents or acknowledgements required in any event. So Sarah, if we please go to the next slide and set Carrie up. Carrie?
Great. Thank you, Pete. And David, great job. You certainly set the pace, for our panel. And I want to thank Pace Nation and Winston & Strawn for including me on this. As you can see from everybody's bios and experience, it's a great group of experienced and accomplished PACE experts. So I'm going to cover today, I'm going to focus on where and when consents or acknowledgements are required and what the real purpose of consents are. And so David did a great job reviewing the differences between notices, acknowledgements, and consents. I'm going to just reference consents when I talk about it because I think of them as universal, and they're typically required in every PACE transaction. But before we determine when senior lender consents are needed, I think it would be helpful to establish exactly why senior lender consents are needed. So as many of you probably know, a conventional element of lender financing documentation is a prohibition on additional subsequent financing or further encumbrances on commercial property that serves as collateral without first getting that prior consent and approval of the existing lender. And this is commonly referred to as a due on sale or due on encumbrance provision. Different states refer to it differently. Typically, these special assessments, including PACE, are not included as a part of this additional financing. However, whether PACE is included, it depends on lots of factors. And so one of them obviously is the underlying security instrument provisions. So if the existing security instrument contains a prohibition, then you're going to need a lender consent. There are also some specific state law requirements and other specific senior lender underwriting requirements. So I can't emphasize enough how important it is to check each recorded security instrument to determine if it contains a prohibition. So that's part of it, but obviously each PACE program is going to have its own requirement of what you need, and whether that's in, as David mentioned, the state legislation or local ordinance, that's to be determined on a state-by-state, program-by-program basis. So what's interesting to me, at least, is that while PACE has kind of been flying under the radar for a number of years, as PACE grows and the industry expands nationally, more lenders are beginning to acknowledge PACE. And in some instances, some of these lenders, unfortunately, for the PACE industry itself, are specifically prohibiting PACE transactions. I have been speaking with several partners in my commercial real estate section, and in the last few months, our firm has reviewed credit facility loan documents from at least a handful of national lenders where the loan documents specifically reference PACE and not just as a special assessment, and they specifically prohibit PACE transactions. And so, depending on what the security instrument says, it'll either prohibit PACE altogether, or at a minimum, it'll require that you get this prior written consent, which may be withheld on certain circumstances, such as financial covenants or other lender requirements. So generally, I would say in agreement, some form of consent is required in almost all of the 22 active states plus the district. And I think the exceptions are California and Florida. The California statute doesn't specifically require a consent. In Florida, there are certain circumstances where consents are required. So once you have an executed consent, what do you do with it? Okay, that's a big question. That's where we get to whether they're pocket consents, we just put them in your pocket or in your file rather, or they go to record. And so again, this differs from state to state. In some states, you simply keep it in the file and you have it as backup in case anyone questions whether senior lender consent was obtained, and it serves as an estoppel for any lender who questions it in the future. And in some states, the lender consent is actually, in addition to being executed, it's notarized and also recorded at closing in connection with the recorded document evidencing the PACE assessment, whether that's a memorandum of PACE lien, a certificate of levy and lien, or you're actually recording the entire assessment and financing documentation. One of these instances is Colorado, where the lender consent is actually notarized and recorded in connection with closing. And, from a strict commercial real estate and finance perspective, I mean, it is prudent to record the consent. And the purpose of that is obviously so that all third parties will have notice that the senior lender consented to the PACE transaction, despite what their underlying security instrument said, whether it's a prohibition or not. That way you've got record for the entire world to see, including bona fide purchasers for value, that, it's not going to create a default under the senior loan. All right, so let's go to the next slide, please. So where are subordination agreements required? I think that's important to note as well. These subordination agreements go a step further than your basic consent. As a reminder, in the PACE industry, a subordination agreement is a contract between the senior lender, the property owner, and the PACE capital provider, where the senior loan is acknowledged, the PACE loan is acknowledged, and the senior lender actually subordinates, it acknowledges and consents to the PACE assessment, and it subordinates that senior loan and its corresponding senior lien to the current PACE special assessment payment that is due, okay, as well as any delinquent PACE special assessment payments. So I think it's really important to note, and I know Andrew's going to do a great job covering this, on how to convince senior lenders to agree to this and why it's in their interest as well to incorporate PACE into their deals. But it's important to note that while the PACE capital provider has a recorded instrument for the entire PACE assessment, the senior lender is really only subordinating that senior lien to what's currently due. So think of it like real estate taxes. It would be as if the senior lender is only subordinating, the lien to the current due amount of real estate taxes. And again, if you go along with that analogy, the senior lender has the ability, if there are any defaults or delinquent PACE assessments due, they can also pay those, add those back into their balance, and incorporate that in accordance with their own loan documents. So the subordination agreements are typically notarized and recorded at closing, just like the recorded consent that I mentioned a minute ago. And again, I think by doing this, it puts all their parties on notice that the senior lender has consented to and subordinated the senior lien to the PACE assessment, so that there's no question of priority and where the waterfall goes. So again, in basic commercial real estate transactions, a subordination agreement is a market standard practice, and I think it's a good practice to have. In at least 2 states, as you can see here, Virginia and Nebraska, these written subordination agreements are required. And they're specifically referenced in each state's PACE enabling legislation. So again, there are only 2 states that I know of, but if I know anything about PACE, I tell you, I can't keep up with it. The one thing that's always constant with PACE is it's always changing and evolving. States, localities, and individual programs change all the time, and it's extremely difficult to keep track of all the new developments. I will give a shout out to PACE Nation because I think they do a great job maintaining their website and including the most current information possible. So I highly recommend that anybody who wants to stay up to date on PACE visits that website periodically and even signs up for the PACE Nation newsletter to stay apprised of new market developments, because it's changing all the time. So if anyone on the panel knows of other states where I might have missed something in the last couple of weeks, please feel free to chime in now. But for now, I think it's just Virginia and Nebraska, and I'm going to talk about those in a minute. So I can't predict the future. I don't know if other states would follow this and add it on there, but I wouldn't be surprised if they did. Again, I'm based on just fundamentals of commercial real estate law. in finance practice, having a written subordination agreement protects all parties in a real estate transaction, and it puts the world on notice, confirming that the lender has consented to PACE. So I think that is something important to have and to have recorded in the public land records. Okay, if we can go to the next slide, please. So here I've just put one part of the Virginia PACE statute, and not going to read it to you. I've highlighted and underlined and bolded certain language there so that you can see where the requirement is. But the point about this is if a PACE capital provider wants the benefit of having the same priority as real property tax liens and assessments, then you have to get that written subordination agreement. I will mention one piece of this legislation that is, it's great if you're a lender. It can create issues for PACE transactions because I think it gives lenders leverage and the ability to withhold their agreement until they get a subordination agreement that meets their expectations. And that's the piece here that says that the written subordination agreement must be in a form and substance acceptable to each prior lien holder in its sole and exclusive discretion. So that's a pretty high standard. And as David mentioned, even with consent, lenders come back and take extra bites at the apple to see what else they can get, whether it's a fee or subordinating or what have you, which would defeat the purpose of this agreement. But at any rate, that's a high standard. So to date, there have not been any PACE deals closed in Virginia. I know there are a few on the horizon. I've got a few in the hopper, hopefully, that may close here before the year end. But, it's important to note that if you're in Virginia, as each Virginia deal progresses and there's existing debt on the property, or say we've got, a new construction deal where there's a PACE component in the capital stack, you have got to get a written and recorded senior lender subordination agreement in order to be in compliance with Virginia law. So I think that's important to note. Next slide, please. Nebraska is another state where it's required, where these subordination agreements are required. The benefit of Nebraska as compared to Virginia, as you'll see, and you can read the excerpt that I left here, but the benefit here is it's a little less stringent so that it doesn't give that senior lender such leverage over the deal, if you will, and it just says it shall be in a form and substance acceptable to each mortgagee or beneficiary. So that's a little bit lighter than the Virginia one. Again, I haven't closed a deal in Nebraska yet, but it's going to be required if you're closing a PACE deal in Nebraska. So let me summarize just to kind of recap before we go on to the next part of this panel. Obviously, a subordination agreement goes a step further than a basic consent. And, this could create issues for senior lenders and the PACE deal altogether, and could cause delays in closing PACE deals. So obviously, this is something that should be started way in advance of expecting when you're going to close the transaction. And then, as everyone on this panel knows, it's hard enough trying to explain PACE to senior lenders and educate them on why they should consent to a PACE assessment on their collateral. But adding the burden of convincing them that, they should subordinate their loans, even if it's just to a PACE assessment payment that's currently due or any delinquent payments, that's obviously going to be a bit more of a challenge. So that's why it's so very important to explain the many benefits of PACE transactions to senior lenders. And with that, I'll wrap it up and let Pete introduce our next panelist. Thank you.
Thank you, Carrie. Very informative and helpful. So now, if you figured out whether or not you're gonna whether you're gonna get acknowledgement of consent and whether it's got to be recorded, but how do you get that deal done with the lender that you're going to chase the acknowledgement or consent from? So with that, we'll turn to Andrew Zeckett from Greenworks, and he'll tell us why would a lender even consider this and what would they require. Andrew?
Yeah, great. Thanks, Pete, and thanks, David and Carrie as well. Very helpful. So, listening to the information that's been shared so far, the thought that runs through my head is, why would anybody do this? This sounds hard. If I'm an owner, it sounds like it's daunting. If I'm a senior lender, it sounds like, there could be risk to my asset and my existing lending. Why would anybody go through this process? What would be the motivations? And yet, despite that, there are hundreds, thousands of these C-PACE transactions that have happened, and hundreds that happen every year all across the country. And so what I wanted to share today is a little bit more around how and why do those transactions happen? What's in it for the senior lender? What's in it for the owner? Because this is a tri-party transaction at the very least, and sometimes many more parties than that. And so I think it's important to look at the business side of this that's driving the PACE industry. So, the first slide that I wanted to share here is sort of why would a senior lender consider consenting? And there are a few different reasons, and I tried to categorize them because, as we all know, commercial real estate is a wide and varied industry, right? But a couple categories of why I am hearing from senior lenders that they're eager to work alongside PACE. So the first one on this list is that PACE projects increase collateral value, period. PACE goes to fund upgrades to real property on existing buildings or to new construction projects that produce better than code buildings. And both of those asset types would be more valuable than if PACE were not involved. And I think that that's kind of the foundational, super critical underpinning of all PACE programs across the country. So just a couple examples here. I was working with an existing building owner the other day, and he was trying to court a long-term tenant that was, ready to sign a 20-year lease for his property, but would refuse to sign that lease until there was a pretty significant overhaul to the energy efficiency equipment in the property. Using PACE financing, he was able to accomplish that. Senior lender was super happy to sign a consent form for PACE because the underlying asset value increased dramatically with that long-term lease in place. Similar, example on an existing building retrofit, we funded just a very simple HVAC and roof replacement on a building the other day. I think it was something like 26 rooftop air conditioning and heating units plus a roof that needed to be resurfaced. That's not necessarily something that's going to help them one-to-one secure a new tenant, but it is absolutely foundational to the operation of the building. And similar on new construction side, there are a million different studies that we can and should be sharing as an industry about how better than code buildings lease faster and lease for a higher rate. So that's kind of the foundation, that the collateral value that the senior lender is holding increases as a result of PACE. The second super important category here is that we're all in business, right? And PACE improves the returns for the end customer, the owner of that building. It's a long-term financing structure. It improves their cash flows. It may allow them to, within reason, bring less equity to a deal or replace more expensive capital. And so if the program is good business for customers, then it is good business for mortgagors. There's an asterisk there. It's not unquestionably good business for mortgagors, but it is, in many scenarios, a good business decision for them. Personally as a lender, I would love to, only lend to the most secure assets and charge, 7% interest rates on all of my deals. But if I did that, I probably wouldn't have very many customers, and David Schaefer and his team would swoop in and take all of my business. And so I don't do that. And similarly, banks and other mortgage lenders live in a competitive ecosystem. And so they are coming to the table because they want to drive more business and they want to do what's right for their customer. Now, all of that only works in the third bullet scenario here where the risk is bounded. And so we're on a CLE webinar. So let's talk about how we are helping to bound that risk. So the first category of risk that I wanted to talk about here is kind of structural risk. We're discussing how C-PACE is a senior lien on the property. And if you're thinking about a mortgage scenario, that sounds scary. A senior lien would have all sorts of rights and remedies in the event of a foreclosure. They would be able to accelerate their financing. They might get in the way of me, the existing lender, foreclosing on the property. I might be wiped out. It kind of sparks a flurry of concern from a lender when they first hear about PACE. And so we spend a lot of our time at Greenworks educating the lending community about the structure of PACE, namely on this page, numbers 1 through 5 here. PACE assessments cannot be accelerated. The only amount that could be collected in front of a senior lender that has those same rights and priority as a tax assessment is the currently due and as yet unpaid amount. And so that shrinks the level of universe that we're talking about from being, the full principal balance. Let's just pretend it's a $10 million PACE assessment. We're not talking about $10 million that could come due in front of the senior lender. We're talking about 1 year's annual payment. The second piece here is that the CPACE lender does not typically have rights to impede a senior lender's foreclosure process. So if the property owner stops paying their property taxes, inclusive of PACE, in just about every mortgage document, that is going to be a default. And so the senior lender would have the ability to take whatever remedies are outlined in their loan documentation to enforce either take control of the property or call a default and kind of work into a workout scenario with the property owner, et cetera, et cetera. Whatever that course of action would be, the CPACE lender would have to sit on their hands and let the tax foreclosure process work itself out, or in a couple states, pursue only that current amount that is due. But we would not have the ability to impede the foreclosure rights. So from a process perspective, the senior lender is not giving up control. And then, a couple other kind of secondary but important mitigants that we deploy frequently. Funds are frequently escrowed with the senior lender during construction. A lot of senior lenders, especially on large construction projects, say, okay, well, in God we trust, but all others bring cash. Where's the PACE money? And so we fund that those PACE funds into escrow with the senior lender. We do release them into the project according to a predetermined set of milestones during the course of construction, but the senior lender has eyes on and partial control over those funds throughout construction. Similarly, on the repayment side, senior lenders may request that their owner escrow PACE repayments alongside other property taxes so that they have sort of this monthly accumulation of PACE repayment proceeds that they are holding, that they have eyes on and can't get surprised. And then finally, as a PACE lender, again, every transaction that I'm a part of is a tri-party transaction, bare minimum. And so we as an organization come to the table amenable to all sorts of other project-specific structural solves. If we actually turn the page to the next slide, one of the things that I'll get into here is that not all projects are created equal. And so some projects you might not need any specific structural solve. Other projects you might need a ton, and you might be restricting the PACE proceeds very tightly to meet the goals of the senior lender and the PACE lender. So Sarah, can we go to the next slide? Great. So those were some of the structural risk mitigants, but again, I think the theme here is that commercial real estate transactions are unique, and each of them comes with its own considerations. In addition to any sort of PACE structural security aspect or risk mitigants that are in place already for a senior lender, that is not just going to set a senior lender's mind at ease. We need, as the PACE industry, to be bringing senior lenders good projects with sound underwriting and well-structured legal documentation. So a couple kind of just examples on what I see at the project level. Senior lenders want to know that they're lending on a good project. PACE does not make a bad project into a good project. It can make a good project into a great project, but it does not overturn a project from being bad. If I brought one of my closest senior lender partners a 600 room hotel 75 miles east of Reno with a sponsor who'd never done a project anywhere close to that size, and they wanted to put in 5% equity, I would get laughed out of the room every single time. But if we're bringing good projects with well thought out construction, well capitalized sponsors, et cetera, that are sized correctly for the market, the chances for success here are infinitely higher. And that might be a Captain Obvious point, but I think it's worth stating out loud. We think of ourselves at Greenworks here as sort of a partner with senior lenders. I don't view these consent conversations as a mother may I. We think that a well-structured conversation with a senior lender is one where we're coming to the table together and saying, we like this project, but together as the lenders on this project, we are going to need to see these project fundamentals be put in place. We both agree, going down to the second bullet here, that the following underwriting criteria need to be put in place. Typically, we're working alongside a senior lender who has relatively set owner equity minimums that they're willing to agree to. And they also have debt service coverage ratio minimums that they would be underwriting against. We like to discuss those with them right up front. We jointly order an appraisal together. We jointly pressure test that appraisal together. And we make sure that we're all comfortable with the structure of the deal and the underwriting of the deal, such that it's never a surprise or a thumbs up, thumbs down at the finish line type conversation with a senior lender. It is a joint structuring exercise together. And I think that that's a really important kind of change in the script from the way that often the PACE industry talks through lender consent. And then finally, and some others have hit on this already, so I'll try not to belabor the point, well-structured legal documentation. There's a consent form or an acknowledgement form that is certainly required in most programs. We as a lender require it on every single project, no matter what, even if we're lending in California or Florida, even if it is a tiny little, solar retrofit on a church, we'll require consent all the time. We think that it's good protection for the senior lender and the owner, and we think that it's just a good industry practice. But in addition to that consent form, there may also be escrow agreements or a DACA that's required. If we're escrowing funds with the senior lender, we'll certainly need that DACA to be in place. There may be a stripped down intercreditor. I think that this is often a topic of conversation. Can PACE lenders sign intercreditors? Of course we can. What can we not do in those intercreditors? We can't pledge to change the course of events in a foreclosure scenario, because if there is a default, there's a real property tax code that is often governing what happens in that event of default. So any consent just wouldn't be relevant. But we do frequently get asked and agree to including notice and cure language. We think that makes a lot of sense. And the examples could go on, but I'll cut it there, and hopefully that's a good perspective on how these transactions come together.
Thank you, Andrew. That's very much appreciated. I guess the next slide goes for me about what the capital markets expect, particularly where you don't have the benefit of a validation order. So I'll try and spend a few minutes on that before we turn it over to Rick and Bob. Here's the thing. The capital markets love PACE. They cannot get enough of it. But the reason why they love PACE is because they see it as a super senior secured asset. So how do we promise to them that, in fact, they're having a super senior secured assets repayment of their bonds or loans? That really goes to sort of what we first did for WR-COG, or in connection with WR-COG, about 10 years ago when that program was being put together. And that was a resi context where getting a lender acknowledgement or consent was impractical. And so we had to rely on the judicial validation process that is employed in California and Florida and Missouri to a certain extent, except they don't use judicial validations. They've got a statutory validation in Missouri. But we ultimately relied on a judicial validation process, which is to say, you go to the courts send out notices to the majority of the big mortgage lenders and say, we are going to put in place PACE. The PACE assessment is going to be senior to your mortgage. Speak now or forever hold your peace. And overwhelmingly, not to our surprise, when we first did this with WR-COG, not a single one of the senior lenders sent in a judicial objection to the case, and the program was validated, and people took comfort on the resi side with that validation process. Meaning that their PACE assessment would be senior and that they would have estoppel arguments at law because the lenders failed to put in an objection as part of the judicial validation process. That may also explain why PACE is in part only in Florida, California, and Missouri, now maybe a part of Ohio and a little bit of New Mexico. But it's not been the best process. Why has commercial PACE flourished in so many jurisdictions? It's the relationship that I think Andrew referred to as not a mother may I, but a partnership with the senior lenders and the consent process that has made people very comfortable with expanding commercial PACE programs throughout the country. So I actually see this as, while sometimes work and a bit of a burden, it is our tool for expanding the map of commercial PACE because it makes everybody comfortable that all stakeholders have a current role in the process. So we, when I represent people who are involved in the capital markets deals, knowing that that has happened in a PACE deal, that there's been an acknowledgement or a consent is vital for pushing forward that. And I think to Andrew's point, irrespective of whether you're in a place like California, Florida, or Missouri, they want to know that the senior lender has been involved. Now, there have been scenarios where we had done a deal and discovered that in fact there was a tax equity deal where the tax equity had tried to put in place an SNDA, a subordinate non-disturbance agreement, for its tax equity, and we really have a problem with those. We understand tax equity for the 5 years. It's critical for them that there not be a foreclosure that disrupts their the tax benefits that they're assuming getting. But we just can't allow a PACE deal to be in a scenario where it could be subordinated to tax equity or to a mortgage, because suddenly the advance rates that we have negotiated for a lot of these deals go from 95 and higher to something much less significant. So we have to be certain that when we're doing a deal, as Andrew said, we might be able to enter into intercreditors, but we just cannot subordinate the payment on the current PACE amounts that are due. And we also shouldn't be looking at scenarios that limit the remedies that would otherwise be exercisable. People really want to see these PACE assessments operate similarly to tax liens and be on foot with the process for foreclosure of a tax lien or a senior mortgage, recognizing that there is no acceleration of the PACE assessment that moves on to the ultimate person who's foreclosing. But for us to continue to maintain those high advance rates, it is critical that these subordination agreements not result in subordination of the lien or restrict the remedies that the PACE provider can exercise, and that we can continue to get consents and acknowledgements from the senior lenders to provide comfort for the capital markets. I know I'm going to pause it there. There's quite a bit more we could say on this, but I want to make sure we've got enough time to hear about the things that HUD is contemplating when looking at a PACE deal. So with that, I'm going to turn it over to Bob and to Rick.
Thanks, Pete, and this is Bob Iber. Rick and I are going to tag team the HUD piece for the next couple of slides. Thanks to you and the other panelists for setting the table of lender consent when HUD's involved. On that slide there, you see our basic guidance. That's the only guidance we have for PACE approval in the HUD multifamily world. And when you go through that, you'll note it covers many of our multifamily programs, but it does not cover healthcare. So all of our comments and our guidance are in the residential multifamily world, not healthcare. Our colleagues in healthcare are still contemplating PACE, and I know a lot of folks are working on them to get there. And I would note that, and we're going to cover that, there are some PACE program assessment requirements that HUD requires. We're going to talk today about the HUD-lender relationship and the lender consent, which you've heard a lot about. Let me jump to the HUD-lender relationship. The easiest part is where HUD is actually the lender, and we have thousands of loans across the country where we are the lender. And because we do want to do PACE, and as you heard in my comments at the beginning, we want to help facilitate PACE in the HUD lending world, that makes it a little bit easier. But in many cases, and we have about 11,600 FHA insured loans across the country, HUD insures the lender against default, and so the lender wants to ensure as part of their fiduciary duty to their partners and the folks that have backed the loan, that they're doing what they're supposed to do, but they also want to ensure that they meet HUD's requirements, because if anything happens with that loan, they have to work with HUD on the claim process, and they don't want to do anything to endanger that process. Sarah, can we go to the next slide? So I mentioned the PACE program assessment requirements. Those are stated right in the notice. I took those right from there. These are pretty straightforward, not going to read them. You all can see those on the screen, and you can see them in our notice. When we put the notice together, we worked with 3 different PACE localities and work through these. As you've heard from the other speakers, these are pretty straightforward. We want to make sure that our lenders are at least aware of those and familiar with them. A through D, again, we think are pretty easy for a state program to meet. HUD does require that the state program meets all of these 4 requirements. The 5th one is the one that we do hear a little bit of angst with from our PACE partners and from our developers in getting the opinion letter from the state attorney general. We've been able to get those from quite a few states to date, but we've also heard that some states, we've heard Ohio, do not give opinion. So we're Rick and I are putting our heads together, and we're going to talk to our attorneys if there's a way that we can work with PACE providers and HUD owners and lenders on those states that don't provide the Attorney General opinion letter. So more to come on that. However, that is a requirement. We are able to get them from states, and you know, where there's an issue, we would like to hear about it though on a particular state. Sarah, can we go to the next slide? So again, what we want the lender to do is part of their lender consent, and in the HUD world, it's not an acknowledgement, it is consent. Review the PACE assessment program that was on the prior slide and is in our guidance. Check the special assessment documents for the impact on the mortgage. You heard some of the other panelists talk about that. And then if there's any related property improvements, depending upon the impact of the property, the lender certainly needs to be aware of those, such as things that are going on the roof or other things that are impacting the property. The lender at least needs to, again, be aware of those. And then, of course, we heard talk about the underwriting. Check the impact on the income and expenses. And what we typically see in that last bullet is that lenders will give a conditional approval subject to HUD's review and approval. And our notice talks about that, and that's actually what we expect. Again, they do that because they want to make sure they're not doing anything that impacts a potential claim with the department under the contract of mortgage insurance. And so we will see conditional approval. HUD will do its review. We try not to take too long in our review. As long as we have a complete package, we usually can get through that in a month or so. I'm going to pause there and see if Rick has anything to add.
Thanks, Bob. Actually, you've covered it quite well. I would point out that in every time that HUD is involved in the transaction, we need to have a HUD review and approval issued. The variable is how much the lender does. All right. When HUD is the lender, it's all one review process. That's a pretty simple track. When there's an existing FHA loan or an existing conventional loan, then we need that lender review, and which ultimately provides us the consent or the conditional approval, and then HUD does its portion. The real difficult heavy lifting is most likely going to be in the terms of a PACE proposal tied in with a new financing, whether it's new construction or a refinance. In those cases, we expect the lender to work very closely with the PACE lender. So FHA lender and PACE lender working together to incorporate the PACE analysis on the loan transaction into the lender's submission to HUD. Now, if that sounds like double talk, basically what we're asking for is that when it's a new loan, we need to see the lender's detailed analysis of the PACE component within the loan and their assessment that it meets all of the criteria specified in our housing notice. So that's probably the heaviest lift, and I think it explains why we haven't seen one yet.
And with that, given some time left over, we'll turn it back for questions or wrap up.
Sure. Before we quickly get into questions, Colin, do you want to quickly take a few minutes to talk about PACE Nation upcoming events, or do you want to move directly to questions?
Let's move directly to questions. I'd just like to thank our panelists and encourage, as Carrie mentioned earlier, folks who are interested in learning more about PACE, welcome you to visit our website, and really encourage you to consider becoming a member of PACE Nation. We there's a lot going on, as Carrie mentioned, and where the community grows every day. So, but feel free to reach out to us, and but would love to hear any questions that folks may have with the time we have left.
Sarah, would you like to plug us into the questions that anybody may have submitted through the system?
Sure. So first, thank you everyone for your participation today, for both the panelists and the attendees for joining us. Attendees, if you have any questions for any of the presenters, you can click the raise your hand button and I will announce your name and unmute you. So I'm going to pause there for a second and see if there's any attendees that have questions for any of the presenters today. We haven't had anybody raise their hand, but there's some that are typing in questions into the question box. So I'm going to read those now, and you're certainly welcome to answer them. So the first one, one person wants to know how they can get a hold of the gentleman from HUD if they'd like to reach out to them and ask them questions. So Rick and Bob, what would be the best way for us to connect you with any of the attendees that have questions for you?
So Sarah, this is Bob. There's a link to the notice and the PowerPoint slides, and you said you were going to send out the PowerPoint slides to all the attendees, and at the bottom of the housing notice and the link is my contact information. But quickly, it's robert.g.ivor@hud.gov.
Fantastic, thank you.
Okay, and for Rick, it's richard.p.doherty@hud.gov.
Thank you so much, Rick and Bob. And also just to remind all the attendees that I will be emailing the PowerPoint deck and a recording of this course after, upon the conclusion, and you can certainly email me and ask me questions to reach out to Bob and Rick on your behalf. So we have a question from Charlene Heidinger. This is for Rick. Rick, could you give a little bit more info about how the lender's detailed analysis of the could Rick give a little more info about how the lender's detailed analysis of the PACE piece? Is this the place where the 14 underwriting criteria and the 1-2017 guidance are addressed?
Well, thank you, Charlene, for the question. It's a good question. And yes, that is our expectations, that the lender is going to go through all of the underwriting criteria in their presentation, their MAP submission, if you will. MAP, we love our acronyms. MAP is Multifamily Accelerated Processing. So it's really imperative that the lender has a seat at the table with the development team early in the process, because they need to understand all of the nuances of the PACE proposal and be able to portray that to HUD as it relates to their overall loan. So yes, all the ratio analysis and debt service coverage numbers, all of the criteria for underwriting as contained, I believe that's section V, section 5 or section 6 in our housing notice. That really should all be addressed. And you know, anything that's missed, it's typically we have a fair amount of back and forth with a lender when a package is received anyway, before we get to approval. So I would expect that that would be the case there too. Now that's a theoretical answer, Charlene, because we haven't seen one yet.
Thank you so much, Rick. Okay, we probably have time for one more question. If anyone has a question, you're certainly welcome to type it in the question box or raise your hand and I'll unmute you. Okay, it looks like we have no more questions at this time. So I just again want to remind the attendees that we will be sending out the deck and the recording of this session after the course, along with a question for you to enter your bar number so we can give you your CLE certification. And if you have any follow-up questions, you can certainly email those to me and I'll connect you with the panelists. Pete, do you want to close this out today?
Sure. Thank you, Sarah. Well, thank you all for joining us today. Thank you to our panelists for taking the time and providing a very informative session. And of course, thank you to PACE Nation for putting on this program and continuing to serve as the leading provider of information for PACE for those interested in the PACE community. Have a good day, folks. Thank you very much for your time today.